And finally, we'll take Doe versus Westmont College. Counsel.
Thank you, Your Honors. Good afternoon. May it please the Court, Adam Johnson for appellant.
Were you here before?
I was here 91 days ago, Your Honor.
Yeah, on Doe.
Sorry?
On Doe, right?
No, it was on a case involving Centex.
I'm sorry?
Centex.
Oh, Centex. Oh.
Wagner versus Centex.
You've already got, I think we filed Centex.
Yeah, it came out Monday, Your Honor.
Okay. All right. So speaking of Doe, you read our case in Doe, didn't you?
The UCSB case,
Yeah.
Your Honor? Yes,
Right.
of course.
And you read the USC case and all the other cases?
I've read all the cases, Your Honor.
Obviously you have. So you're telling me that this was a fair hearing?
Yes, I believe it was, Your Honor.
I'm going to be right up front with you. I sure don't see it that way.
Well, let me address the UCSB case since the court cited that or referred me to that. This case is very different than the UCSB case. That case involved a public school subject to constitutional guarantees of due process. As the court pointed out in its opinion,
do you think the standards are different between private universities and public universities in terms of the fair hearing requirements?
I think they should be, Your Honor. I think
should be. I think there's 4 or 5 public university cases, a couple of private university cases, and my reading of the law so far is that this due process argument is a statutory argument. It's not necessarily grounded in a constitutional foundation. Is there some? What is your support for the argument that the law recognizes different duties for public universities, which are higher than those for private?
I think I would say it's every reference in every one of these cases to the fact that there are different considerations for public versus private universities.
In McKenna? Isn't that what's the one that Justice Bendix wrote? That was a private college, I believe.
Yeah, I mean, USC's private school, Clark McKenna's private school. Yeah. There are lots of private schools, and I would agree that in California the cases appear to have kind of eroded the public versus private distinction, because it's just easier to have one standard. I think the court in the recent.
When you say eroded, that's implying that there's some kind of rule that private schools are different than, well, they are in many respects, but for our purposes, that they're different than public schools, and that there somehow was some kind of policy in effect in the past, and that policy is eroded now because it's easy to have one policy. Come on.
Well, no, I think that's actually the case, Your Honor. If you look at every one of the cases, they say, usually in a footnote, public versus private is different, but for practical purposes, we're going to treat them the same, or the same factors mirror, the fundamental fairness question, which applies to private schools, mirrors that of the due process guarantees that public schools have under the Constitution.
Is there but is this founded or just grounded in a constitutional foundation or a statutory foundation? Isn't this like the due process that comes out of, excuse me, 1094 and so forth, as the statutory basis?
It's the due process issue stems from the constitutional guarantees that apply to public schools. The 1094.5 just talks about fair procedure, basically. So in terms of whether the court's going to treat public versus private schools the same, I guess my point in pointing out that issue is just to say, yeah, these are different types of cases. Different considerations apply to public schools versus private schools. Private schools just simply don't have the kind of resources that public universities have to address all these types of issues.
So let me just say, so what?
Well, it's unfair to private schools.
Well, no, but if we're talking about basic concepts of due process and fairness in a hearing, whether someone has the resources or not isn't a consideration that goes into the calculus, does it?
Well, I think it should
Well,
be.
we didn't really have the money, so therefore it's okay that some student's career may be ruined by having a hearing where the evidence is not presented in a fair and appropriate manner.
Well, it kind of gets back to the origin of this whole thing, Your Honor. Prior to the USC case, which came out in August of 2016, courts routinely were extremely deferential to decisions that were made in internal disciplinary matters like this. The Westmont decision came out in May of 2016, prior to all these cases. And as the court knows, there's been a spate of recent cases addressing all these issues. But in all these cases, they say basically that the hearing requirements are flexible and entail no rigid procedure.
Yes.
And that stems, Your Honor, from the fact that pre-August of 2016, many schools like USC used like a single investigator model where an investigator looked at the case and made the decision whether or not there was a violation of school policy. And that in turn stemmed from Department of Education guidelines and court decisions that basically said, schools, you don't have to change your procedures. We're not imposing any new requirements. Just keep doing basically what you've been doing.
Yeah, that doesn't mean it's right, of course.
Well, that's correct, Your Honor.
Is dynamic and changes, and courts look at things, and then there's no certainty here. We try to get as close to it as we can, and then courts look at what's been going on. All of a sudden, a decision comes out. Wait, this isn't right. Well, we've already done it in the past. I mean, I could mention Brown versus Board of Education, but I don't want to get too highfalutin here. But I'm just pointing out that the law is dynamic and it changes, and I guess I'm just posing the question, private or public, these are kinds of concepts that at least the cases, and at least I seem to indicate, cohere in society.
I guess my point, Your Honor, is that there's no fixed procedure in these types of cases, and the case history says that there is no procedure. Here, we're going to give you another hint now of what does pass muster and what doesn't.
But there are certain, I mean, as we pointed out in the Doe case, which I realize is the University of California, there's certainly a due process. I forget the language that I used in the opening, but it's something hard to define, but we always know when it's absent. And the point is we're not following the evidence code per se, but we're just following general notions of fairness. If somebody's accusing you of doing something, can have a profound effect on your future. You got to have evidence. You got to be able to ask questions. You have to balance it so the victim doesn't suffer humiliation. That's true. It's a very tricky thing. We all understand that. But there's some cases you look at it and you say, what? The evidence, the witnesses weren't allowed to be there, or they weren't allowed to cross-examine, or those kinds of things make an impression on anybody, and certainly on a court. So,
well, Your Honor,
the
cases that I've seen that where the court has found that there's a problem in terms of fundamental fairness are situations in which the complainant, for example, didn't even show up. It was not, interviewed by the person.
Happened in the McKenna case, I think.
Correct.
The person didn't have to be there to be cross-examined.
Correct, Your Honor. And then in a lot of the USC cases, which don't involve any hearing process at all, a lot of those are decided just based on like witness statements and not live testimony. So the cases that have found a lack of fundamental fairness or due process involve those situations where the fact finder or decision maker, which is basically the same thing, doesn't have an opportunity to question the person.
Well, let's talk about that.
Yeah, go ahead.
Because that's a problem in this case, isn't it? I mean, some of the witnesses were never observed by the decision makers.
Well, I guess maybe that's the case with something like 4 witnesses out of,
Yes,
the
four
panoply
witnesses
that were there.
But the decision makers specifically cited the evidence provided by, I think, 3 of those 4 witnesses. It said we're making this finding based upon this witness's statement that we've never observed. I think we can. The record's clear. I think you'll concede that. My follow-up question to you is this. Doesn't that cross a fundamental line that all of the cases put down?
No, absolutely not, Your Honor.
Tell me why.
The cases say that there's only really a lack of fundamental fairness when a particular witness is critical in the case. In this case, really, it was basically a he said, she said type situation.
Yes, but here we have the decision makers saying that, well, it is a he said, she said, and this witness said this, and this witness said that, and we believe that witness, the one we've never seen. Well, I mean, does that make that witness a critical witness?
No.
I mean, what's your definition of a critical witness?
A critical witness is a witness whose testimony is necessary for due process, basically.
Like finding that they're more credible than the other version?
Well, it's for example, it would be the complainant, I think, is a critical witness, particularly where in a case where it's a he said, she said type situation. If there haven't been admissions by the respondent that...
Okay. And I understand that. I understand why the cross-complaint is important, but the courts probably wouldn't use the word critical witness for a victim or an accused or an alleged victim and an alleged accused, to be more careful in my phrasing. Doesn't critical witness convey a third-party observer?
I think in the recent allege case, I think it can be interpreted to do that. But again, I don't know that it actually says that.
No, I don't know that it says that either. I'm trying to see if you can convince me or us that a witness who provides testimony which is the basis for a decision in making credibility determinations is not a quote, critical witness, end quote, under the case authorities.
Yeah, I mean, it seems like from my reading of the Ali case that they're talking about witnesses that actually observed the conduct or had some percipient knowledge that would be important in the case. The witnesses that I think you're talking about merely confirmed or other information that either the complainant or the respondent provided.
Well, I mean, in this case, don't they say something like, well, we didn't see the incident because nobody did, according to the alleged victim. I mean, that's what the accuser is saying. The accused says it never happened. Nobody saw it. It's her word against his. But those witnesses that we're talking about also said, well, we were the first ones to see her when she got back, and she said, this happened to me. So I'm just asking you to help me out here. Why is that not a critical witness?
Well, because the complainant said that that's what happened. The witness that said, or that confirmed that she said that happened,
even though the complainant's
cumulative evidence, basically.
Even though the complainant's credibility is the issue in this case. Isn't that the issue? The complainant's credibility?
Well, it's the complainant's credibility and the respondent's credibility.
Correct. That's the issue.
Yes.
So, confirmatory, wouldn't that be critical?
I don't.
On either side, his or hers?
Not necessarily. I don't think so, Your Honor. I mean.
Okay.
Just to go through the USB case, since I started on that, some other distinguishing features of this case from that case were that there was no audio or transcript of the hearing in that case. And it seemed to me that the court was it was difficult to deal with that case as a result, particularly since, based on my reading of the case, UCSB was supposed to have audio tape the proceedings according to their procedure.
That was part of it. I mean, that there's going to be distinguishing. I don't know if those are critical distinguishing factors.
Well, okay, well, I'll jump to that. What I think is a critical distinguishing factor is that UCSB's procedures explicitly provided that an accused student shall have the right to confront and question all witnesses. And that's not something that's provided in Westmont's procedure. There's no right to confrontation of witnesses. The reason this is important is that, back to my original point on the due process, fundamental fairness distinction, at private schools where student discipline is at issue, the university must comply with its own policies and procedures. You don't go outside of it and look at issues of due process beyond that. It's basically the students are entitled to what's stated in the
Here's where I'm
handbook.
differing. I mean, we could argue this all. I think we can argue this all day. True, a university may have certain policies and procedures. What at least I think I'm interested in, I don't want to speak on behalf of the panel, whatever the policies are, there are certain basic requirements of fairness. And that's what I'm just being upfront with you, is missing here. I don't care what their policy is. I do care, but I'm saying if the policy doesn't comport with that, it's no good, because a student's whole career can be. Now, maybe it happened, maybe it didn't. That's not. We're concerned with having a fair hearing, and fine, they may have followed the procedures of the university, but are those procedures appropriate?
Well, under the cases, Your Honor, I think they are.
Yeah, I know.
They held a live hearing, which many schools don't do.
That's true.
They had many different witnesses come in that the decision makers had the ability to question, cross-examine, ask questions to.
Except for the 4.
Well, yes, Your Honor.
Right.
They refused to come in, but I don't know what the court thinks a school is supposed to do when a non-essential witness says, I'm not going to come in. As the court knows, schools don't have subpoena power. They can't compel witnesses to come in. So
I think the argument,
I
think the argument on the other side is, you can't make them come in, so you just don't rely on a statement that somebody made that said that they said something. In other words, you base your decision on what you do have the ability to observe.
Well, I mean, is that the case when the witness has already provided a written statement regarding the testimony?
Well, that's why I asked. That's why I posed the question earlier about, and that's why we debated. Well, is it a critical witness? And so I understand your position is, well, it's not a critical witness, and so you don't have to have that. But I think what I'm hearing you concede is that if it's a critical witness, then it has to be, then they have to be subject to observation.
Well, I would agree.
Or maybe you're not. Maybe you're not conceding that.
Well, I would say if it's a critical witness, yes, but I wouldn't agree that anybody other than the respondent and the complainant in a he said, she said situation is a critical witness.
I get that. That's what I was meaning to define. That's the area of inquiry, the way that you're posing the question.
Of course, if you have a he said, she said situation, corroborating witnesses can be vital. That's the whole point, I guess.
Yes, Your Honor.
Yeah, I just went under the fray just a bit. It's hard for all of us who are steeped in concepts of due process to wrap those words around the procedures that we find here. At least I say that for myself. And I'm trying to fathom, now that there has been this burgeoning of cases, where's this going? What is the... Well, I'm having trouble because it's like trying to nail gel to a wall. This thing keeps moving around. Maybe there are witnesses there, maybe they aren't. The very statement, critical witnesses, is a conclusion formulated without the witness present. well, that wasn't a critical witness. And the whole case is being driven by, frankly, a kid representing himself with no guidance and no participation by an attorney who's even allowed to talk. It just drives me up the wall. Now, that may be okay. And I understand, let me throw it to you this way, but now that I've finished pontificating. I can understand schools have to be able to react to the environment that they protect and make a safe environment for the kids. I get that. And these proceedings seem to be the kind of acting out, remedies for the kind of acting out, they put some graffiti on a wall, or they had a panty raid, or what, I don't even know if that's a fair statement anymore. Whatever the heck they do, that kids do. We're talking here about sexual violence. We're talking about a case which, if prosecuted in a court of law, a criminal court could result in a sentence of multiple years in prison. And the kid walks in there making statements and floundering around. How does due process kick in here? How raw can it be that you just say, well, we'll have one investigator and you, kid, come on here and you put on your case? Isn't it just fraught right from the beginning in a case like that?
There are a lot of thoughts there, Your Honor. I appreciate the court's thoughts. The reason schools have to handle these things this way is because the Department of Education says that they do. And the department so far hasn't provided any clear rules or hard and fast rules as to how to do it. There are some regulations that are, they're being considered that may come down, that may help sort out all this stuff. But until that takes place, it seems to me that the courts are going to keep seeing these types of cases because, at least in California, the writ procedure is the proper procedure for kind of bringing these things to the attention of the court. And as I pointed out previously, these are still internal disciplinary matters, even though they involve sexual violence or sexual assault sometimes. The school has to address those. But what's happened is that the courts have basically, it's kind of like whack-a-mole, where each case will come up and the court will say, well, you did this wrong, but not provide any clear guidance as to what you're supposed to do.
No.
So
you want us to? I'm sorry. This has turned into a broad philosophical debate, which I really don't want to do.
Right.
I'm sorry, and we've caused that by some of our comments, or some of mine at least. What do you want us to do here? I mean, I understand you have a client to represent, and you want us to reverse it, but I'm just saying, what kind of guidelines are we going to give here? What are we going to say? What do you want us to say?
Well, I want the court to explain what it thinks due process should have consisted of here if it doesn't think it was provided in this case.
I think,
fundamental fairness.
Don't the other cases do that? The other cases explain why. It's hard to get an absolute template that's going to cover every situation. So if you look at all the cases together, you can come up with some, hey, you get to see the witness. You don't have the school's lawyer there making evidentiary objections in our Doe case. There's an amalgam of procedures, and you get it. And each case will discuss some of those procedures. And bright lawyers like you, who have a really tough job, you have a client to represent, and the court immediately is coming all over you with, it's not your fault. We're just trying to come to a reasoned decision. You take on all those cases together, and you come up with something. And you advise your client,
Well, I respectfully disagree with the court in terms of, I think this case did provide fundamental fairness based on the case law, all of which came out after Westmont conducted its process.
Well, I don't know.
Again, Westmont didn't use this single investigator model. It had a full-blown hearing, had many witnesses come in. Unlike the CMC case, every person on the panel had the opportunity to question and see the witness's demeanor and evaluate credibility. the panel also provided with the parties with the ability to conduct a form of indirect cross-examination by informing them of the testimony that occurred during the process and soliciting issues or suggestions from them as to what to ask the other parties, which I think goes far and beyond what is required by the other cases. A couple of other matters, Your Honor. The respondent did have an attorney present during the entire proceedings. He wasn't allowed to actively participate, but the Department of Education says that that's fine.
No, it is. In fact, in the Doe case we had, the lawyer was there and didn't participate. We agreed. We understand.
And he was the only attorney there in the room. There wasn't an attorney on behalf of Westmont there making evidentiary objections like the court pointed out occurred in the I think the UCSB case. Again, there's no specific hearing requirements. They're flexible. There's no rigid procedure. And I think Westmont was ahead of the curve here in terms of these new requirements.
Yeah.
The most recent being that you have to perform some form of cross-examination in cases turning on witness credibility. The courts have made it clear that that's so the fact finder can evaluate credibility. The parties don't have to be there. They're not there in a lot of these, especially in these single investigator cases, and the courts have not said that they have to be there. I think one of the key quotes out of one of these cases that I think supports Westmont's position that the process it provided was fair was in CMC, and I'm quoting from that case. While we do not wish to limit the universe of ideas of how to accomplish... Oh, sorry. Let me back up. The court stated in CMC, a school's obligation in a case turning on the complaining witness's credibility is to provide a means for the fact finder to evaluate an alleged victim's credibility, not for the accused to physically confront his accuser. And the court went on to say, while we do not wish to limit the universe of ideas of how to accomplish this, we know that the mechanism for indirect questioning in the UCSD case, including granting the fact finder discretion to exclude or rephrase questions as appropriate and ask its own questions, strikes a fair balance among the interests of the school, the accused student, and the complainant. And that's at the CMC case at page 1073. In that case, in the CMC case, the court said that questions by the panel or by the respondent would have been sufficient. In this case, I think Westmont's procedures were clearly within the universe of providing a means for the fact finder to evaluate witness credibility, and that therefore that was the reason that the procedure was fair. There are a lot of other issues I've dealt with, or I've responded to most of them in the reply brief.
Okay.
But with that, Your Honors, I'm willing to turn it over to counsel.
We've had you against the ropes for quite a while here. Okay, thank you.
Thank you, Your Honor.
Mr. Hathaway.
Thank you, Justice. I wanted to address the private versus public issue briefly. Keep in mind that this all came out of the colleges accepting federal funds, the taxpayer money under Title IX, and that's where these rules and regulations came about. The 2001 guidance, which is still good guidance from the Office for Civil Rights, requires that the colleges provide due process for all participants. So if you don't want to accept the money, you don't want the due process, just don't accept the money. The other issue regarding 1094.5 is, remember 1094.5 came about for the courts to deal with decisions made by governmental agencies. And so most of the decisions, until you have Pomona College case, Gupta versus Stanford case, those generally involve in 1094.5 some governmental agency where due process is required. And so that would be typical within in 1094.5. There's an element that due process should be required. I do also want to address the issue of I don't know if there's anything that the court needs me to address. The critical witness issue, it's not just one critical witness, it's accumulation as well of witnesses that I don't think a student needs to hit a home run with every witness being critical, but when you take away 4 witnesses among who were the first people that the complainant spoke to, that creates an issue.
Were there affidavits or any other forms of evidence, be it hearsay or otherwise, that presented to the fact finder, of those events that happened, and to which those witnesses would have attested had they been permitted to file a statement or testify?
The process is that they're investigated, or they're questioned, interviewed, in this case by, I believe, Stu Kleek, the investigator. There's no record, there's no verbatim transcript, they're not recorded. He writes up does the best that he can to write up a narrative of what took place. Those narratives, I believe, became part of the investigation report, that then part of the documentation that was provided to the panel.
So the information of those 4 witnesses was, in fact, before the panel?
Well, then the issue is they're not affidavits, they're not under oath. You'd have to assume that Mr. Kleek, depending upon his abilities and background, accurately conveyed in his written summaries what the witness stated.
But here we come to the issue of my earlier screed, and that is you're moving into the realm of formalism and due process as we know it within a courtroom. The minute we're bringing bodies in and all the things you're saying that not simply present the evidence but present it first person and live. Now we're in trials, and the whole point of this exercise is, as repugnant as, I'll be very honest with you, as repugnant as these procedures are to me, that appears to be the state of the law. If you get the information to the people, that's enough.
It's not the state of the law, Your Honor, that just getting the information to the fact finder, summarized by the university or college's investigator, Doe versus Bob, the Claremont McKenna case, the USC case, all requires actual cross-examination of some form because it's the greatest engine for truth that has existed. And this isn't it isn't that the universities, who are our best and brightest, somehow had no concept of what due process is or just basic notions of fairness, that they had no idea what that is unless they're told to do something by the court or by the Department of Education. Due process, fairness is clear to children, what's fair, what's right. And the colleges spend significant energy crafting policies that skirt at every edge of the due process points. The right to notice, the right to be told clearly what you're charged with, given access to the evidence and a reasonable opportunity to present a full defense to it.
And your point is it didn't happen here. That's what this case boils down to. We've gotten into these long, broad philosophical discussions, but there's cases out there. We've written one. So the question is,
well, thank you for that
case. Did they do the right thing here or not?
I was the attorney sitting there not being able to. I was the potted plant in the UC Santa Barbara case.
Yeah.
And it is somewhat frustrating to try to instruct a student when they're faced with highly educated personnel and they have extremely serious consequences, being labeled as a perpetrator of sexual violence. And in this day and age, as we could see in recent Supreme Court nomination hearings, that can last a lifetime. And it's extremely important. It's extremely important that the schools get it right if that's what they're going to stay in the business of doing. I did want to I don't think it's specifically before the court in this case, but in both the respondent's brief and in the reply brief talks about the deference that the court gives to colleges. There is no deference in college discipline cases. There is in academia because the court shouldn't be substituting its judgment, but certainly in discipline where there's facts, determination of facts, that's something that the court should do all the time.
Well, if we're considering essential due process arguments or concepts, there's no deference. It is or it isn't. But it's different as Justice Perrin pointed out, in a private or even a public university setting as opposed to a trial. But the point is, there's certain basic. That's what we tried to say in Doe.
This gets to, though, the substantial evidence test and the deference that courts seem to be under the 1094 writ process, deferring to decisions made by private entities. The whole deference comes out of Eubanks and Fukuda. It was all because the court was deferring to other branches of government. It's Bixby. It goes back to Fukuda. That's where the deference comes from. Here, it's a separation of powers. Even the court's determination whether this involves a vested fundamental right all comes out of determining what level of scrutiny the court is supposed to give of a governmental agency decision and deferring because of the separation of powers. Here, in all of these cases, you have essentially two private parties before the court. Neither is entitled to deference over the other. It's also a public-private issue, even though the University of California is essentially a private corporation, has significant rights and operated as a public trust, but there's an issue whether all the people that work for the University of California are public officials entitled to the public duty presumption, all of which gives the court reasons to defer to governmental agencies, but no basis whatsoever to defer in the case of private colleges especially.
If what you're saying is true, then don't we have almost the de novo obligation to review the record to see if, in our opinion, not simply sufficient, but we would have decided that case the way it came out?
Yes. I think under the UC San Diego case, the litany of how deferential the court is to be in those cases certainly does not apply to private entities, and I think it became clear in the Ali case that just came down January 4th that what has happened over the last number of years that this problem has developed is the accuser is literally never questioned throughout the entire process. The accusation is believed, and the presumption here, and you can see it in the decision made by Westmont that the respondent was not able to prove essentially his innocence. He wasn't able to overcome their presumption that it must be true. So you have accusations that are never questioned throughout the college process, and then you have a superior court that says, well, we're going to defer to the college, not do de novo review on the factual and evidentiary issues, so that's a pass. And then the Court of Appeal essentially says the same thing. So it means the accusation, if you get an accusation against you, you lose. There is no check along the way. And in fact, I would argue that because under the first prong of 1094.5, whether the process was fair, the college has to weigh the evidence. But if you'll see, and it's not as clear in this case, but certainly in the UC Santa Barbara case, that they don't weigh the evidence. They merely look for evidence that supports the original accusation. That means the college or university did not use a preponderance of evidence, which they're required to do under their rules and under Title IX rules. They merely look for whatever evidence might tend to support the original accusation. And then the Superior Court punts and says, well, we're not going to look either. So an accusation never questioned, no cross-examination, no doubt, no challenge by anybody along the way becomes...
You're not talking about the facts of this case, are you? You're mounting a discussion about your feelings about other cases, but that's not this case.
I was encouraged.
This person was questioned. This person was called a liar by many people. And so I don't think it's fair to come in and say that this accusation was just automatically believed and never tested. The question here is whether that test was adequate, not whether an accusation that was made that is just going to be accepted without question.
Well, I think ultimately the college did essentially discount everybody who said she's a liar. They didn't bring those witnesses in.
It appears that they believed her, but to say that she wasn't questioned ignores a lot of investigation and a lot of witnesses that were asked questions and brought into a hearing.
Yes, I would concede that, Your Honor.
Okay. Thank you.
Well, I started us on too much of a philosophical discussion, I think, because of my discussion with counsel. But, I mean, we're talking about this case, too. So I think we beat a dead horse here, but go ahead.
I certainly...
While we're putting the last spear into the horse, I just have one question. In your exposition, there's an issue of a starting point where the trier has some guidelines, something, and knows what it is responsible to do, and at least what the burden is for preponderance of evidence, however it's described. Does the trier of fact, whomever that may be, have that as a matter of guidance, a booklet, anything that says, by the way, you're going to be in charge of this deal, there's some rules here?
It is hidden within the policies. And if someone is astute enough to figure out what rights they have under the policies, that they can insist that they're provided the evidence before they have to respond to it, then yes. But you have to be astute enough to do that. And most students, we're talking usually freshmen, people just out of high school do not have that ability. I hope I answered that question.
I think we've unless you have something else you want to add.
No, the only point was there wasn't 6 full days of testimony. There was a breakup of this. There's not a record. I don't think Westmont, although they're good college, nice people, great mission statement, I don't think they should be commended. I don't think they were ahead of the curve. They're kind of behind the curve. And anyway, I appreciate the court's attention.
Thank you. So, Mr. Johnson.
Yes, Your Honor. I just wanted to respond to some of the points
Yeah,
that
sure, please.
counsel made. In terms of how the people at Westmont know what to do in these types of proceedings, they're all required by Title IX to be trained in these types of procedures. And Westmont has to have a policy in place that complies with Title IX, or it will, be subject to oversight by the Department of Education. So the procedures are published, they're available, students can review those, and they know what the procedures consist of. I believe they're in the administrative record. They're pretty extensive.
Just one quick question on that point. Is there anything at all when somebody is accused, they hand you a booklet saying, dear accused, you're going to go to a hearing and you have a bunch of rights, as narrow as they may be, 2 or 3 pages, anything that says to the accused, you've accused, these are at least the minimum standards we're going to adhere to and what you have to do. Do you get anything like that?
I believe so, Your Honor. I think there's a page in there that says rights of either the accused or rights of the rights of the respondent, rights of the complaining party, or there may be rights of both parties in Westmont's handbook.
Yeah. So.
A couple other points. the implication that Westmont has a choice of whether to decline federal money or not, it's not really a genuine choice. Almost every student I know gets a federal student loan. It would not be able to accept student.
That's not going to affect how we decide this. This is giving us a little background, but this is not germane to our decision.
I don't know if the court noticed, but there is a part of the administrative record where it makes it clear that the panel did attempt to get these witnesses that respondent is saying, should have been interviewed. They just didn't want to participate. Yeah. And they, to answer Justice Perrin's question, they did provide statements, written statements, prior to the hearing, and both the parties had the opportunity to address those written statements and respond to those. Some of the witnesses, my impression was that they were affiliated with the respondent, and I don't know whether he took any steps to ensure that they didn't show up, but that's always a possibility in these types of cases. So you can't rely on, you can't rely, I guess, on non-essential witnesses to drive these types of matters. Just a small point.
There was also a complaint made that Mr. Kleek's interview notes were not turned over. You agree that that's an accurate statement?
I agree that claim was made. I don't.
No, I mean that his interview notes were not turned over.
I don't know if he has any interview notes. I think he turned those notes into the write-ups that were provided to the parties. I
think write-ups were turned over. I think the complaint was made that the background notes were not turned over, and Westmont has a policy saying that the accused is entitled to everything that he develops during his investigation. And so the argument is made that Westmont violated its policy.
I understand that's an argument. There's no evidence that he had any notes, is my point, other than what was typed up.
Okay.
As the court pointed out, extensive cross-examination of the witnesses took place, including of the complainant, which caused her to claim that she wasn't being believed. The panel was not soft on her at all, as Respondent's counsel is trying to make it out. The accuser was questioned at length. In terms of the substantial evidence standard of review and the deference, I was just citing the UCSD case, which makes it clear that when you apply that standard to the substantive findings in the case, it's an extremely deferential standard, and that's a quote from that case. The fairness issue, it's another issue. It's a different standard. But that's where that extreme deference comes in, and I disagree with counsel that it's somehow only applied if it's a public school or in some sort of governmental administrative proceeding. And I can't help but keep coming back to this idea that Justice Perrin has noted that these kinds of proceedings are becoming more and more like a courtroom, despite, from the very beginning, almost in every case, saying that the primary goal of educational institutions is to educate its students, not turn its classrooms into courtrooms. Yeah. But that's essentially what's taking place here. I think the courts kind of got off track by going down this track, but I think even taking into consideration all the case law that's come out since Westmont issued its decision, Westmont provided fundamental fairness to the respondent in this case. And so that would be the basis for me requesting that the court change the trial court's decision. One last matter, sorry, Your Honor. There's this idea that keeps being brought up about this may ruin this person's life, or it may have really serious consequences. But all these proceedings are confidential at the school. It's possible that a student or witness can disclose information from them, and the school tries to prevent that, they make it clear that you're not supposed to discuss this.
If they're expelled from the school, though, that's part of the record.
Well, what record? I mean, one thing that counsel argued in his opposition brief is that there'll be a permanent notation on his transcript, which is absolutely not the case.
So what does happen?
What happens is he gets a letter saying he's suspended and setting forth what he needs to do to get back into the school.
Is there any record of the reason for the suspension?
Just that.
Just that letter that is in his possession?
Yeah. We don't put a notation on a transcript or anything like that. He can go and, pursue his degree at another institution if he wants, or he can do what the school said it would be necessary for him to do to come back.
So the other institution would never know that why this student was suspended?
I believe that's the case, Your Honor, but it's entirely possible the school could ask, well, why did you leave this other institution?
Want to go to medical school or law school and there's questions about the past?
He was not expelled.
Okay.
He was suspended.
Anyway, I think we're going over a lot of
Okay.
ground we've tread already. Thank you.
Thank you, Your
The
Honor.
matter is under submission.